He specializes in tax and transactional structuring solutions and has significant tax litigation experience. I have worked with Andrew in the past, and I know that he has excellent relationships with numerous South African regulators. And he also has written numerous articles and has been included in several international lawyers' publications. So Andrew has been a guest of ours before. So welcome back, Andrew. Glad to have you today. Today we're going to look at, we're going to follow on from a number of presentations we've done before on the topic of financial immigration. You guys will all be aware of the various legislative changes that have been proposed and how those will affect your investment opportunities. I think we've always got to continually look at estate planning and the effect of the relaxation of exchange control rules on that estate planning, how it's going to affect your investments, and how you look at managing your wealth going forward. So today we'll particularly focus on the proposed exchange control amendments in the 2020 budget speech that have been implemented, and then the amendments to the Tax Act, which Andrew will cover. Once we do have a chat function, so any questions, please feel free to put them in the chat function and I'll pose them to Andrew as we go. We are recording the session, so we will send it out to all those clients that have registered. And let me hand it over to Andrew, and we'll touch base after the presentation. Thanks very much, Andrew.
Thanks, Flynn, and thanks very much for having me, and welcome to everybody. This is, I think, an interesting discussion, and possibly not the first time that some of you may have touched on the topics that I'm going to talk about. But I do think that it is very relevant and some of it's complicated. So if it's the first time you're hearing it, hopefully it'll be an interesting tax talk as opposed to a normal tax talk. And if you've heard it before, hopefully you'll learn something new and we'll clarify one or two issues. So really the discussion starts in February 2020. Budget speech 2020, a world before we know what COVID is, but the pandemic hasn't hit our shores and we're not sure what it means. And the minister makes a budget speech, and in the budget speech, the most significant thing he talks about is revising the capital flow system, which is essentially exchange control. Now, it doesn't get that much attention, and to the extent that it does get attention, it's overshadowed by the pandemic very quickly. Suddenly people are learning to lock themselves in their houses and make pineapple alcohol. So instead of focusing on what the budget said, people are just going about surviving locked up in their houses. So quite understandably, it loses a bit of emphasis. But if you read what was said, it's quite sweeping. And what we're going to focus on today are the changes that have been implemented and possibly what we expect going forward. Now, I'm going to start with the tax changes that were announced in this year's budget, 2021. And I'm not going to dwell on them for a very long period because today the overarching theme is estate planning. And just to refine that a little bit, it's estate planning in South Africa, where the capital flow system or exchange control has been revised, and what does that mean for us? Obviously, there are always interesting tax changes, and they cover a range of topics, including VAT and international tax. But what I can say is there was nothing material in the 2021 budget insofar as what we're talking about today is relevant. So nothing massive was announced which changes the way we do anything or will make us reconsider anything that we're going to talk about. So in fact, what I am going to say is that in light of the continued changes to the exchange control regime, the tax changes announced in the budget were fairly light and therefore don't require us to dwell on them any further. That said, please bear in mind the way that the taxation laws amendments are implemented is that the announcements of the major changes are made in the budget, and then there is an amendment bill that comes out in about June or July. And it's not limited to what was said in the budget. So, of course, for those of you that are tax nerds, or that know tax nerds, you'll be keeping an eye on what comes out in the changes, but nothing dramatic in the budget. The only thing that may have affected you, and it affected all of us sadly, is the fact that the sunset clause in Section 12 capital J of the Income Tax Act was not extended. For those of you who've used that, it provided a very handy tax deduction for investments in venture capital companies, and that wasn't extended. So that is a pity for particularly some individuals that were investing in those structures. You do have one more round for the 2022 tax year, but that's going to be it, unfortunately, and you have to act quite quickly. So as I said, the 2020 budget announced some fairly dramatic changes, including an overhaul of the capital flow system. And that is well underway. And the evidence of it that we see are a couple of notices that have come out. Now, let me just explain how exchange control works for a minute, because a lot of this talk is going to be focused on exchange control. The primary source of exchange control legislation is the Currency and Exchanges Act. And if I'm not mistaken, that goes back to 1933. There are then certain regulations, which is a secondary form of legislation if you're a lawyer, which then enhance and explain the Currency and Exchanges Act. And then pursuant to the pursuant to the regulations, the Reserve Bank effectively was vested with the power to produce what we call the manual, which is a manual for authorized dealers. And that contains what we call the rules or the rulings, and it's got it's a policy document that can change from time to time, and it really expresses what the Financial Surveillance Department of the Reserve Bank, who are the guys that administer exchange control, believe is the law. The way that they amend that is they do it by way of notification. They release notices on a sometimes monthly basis, but on a whenever basis. And those notices then tell you what the policy changes are. And we're going to be talking about two notices today. The first, as Flynn said, relates to this issue of financial immigration. And I believe it was last year, unfortunately time has blurred a bit in the pandemic, but I believe it was last year, we did a talk on financial immigration, tax residents, and exchange control residents. Okay? And for those of you who attended, you will remember that financial immigration loosely referred to ceasing to be an exchange control resident. And we pointed out that tax residents and exchange control residents were different concepts, and that there were different processes to cease to be resident under either regime. What has happened very recently, and again, as I will repeat several times, is that going back to the 2020 budget, it was announced that immigrants and residents would be harmonized or treated the same. So let me put that differently. If you had immigrated from South Africa, there were specific exchange control rules which applied to you. And obviously we're talking in an exchange control sense. So I mean in an exchange control sense. And if you were a resident, there were a different set of rules that applied. Now, what they've done is they've released a circular which effectively does away with the concept of an immigrant. In other words, immigrants are treated the same as residents. So what does that mean? That means that all of the allowances that residents can access are now available to immigrants. In addition, you were probably in a slightly worse off exchange control capacity if you were an immigrant, because some people had what we call blocked funds, although in more recent times, these hadn't been as common. Generally, exchange control, if you were immigrating, would let your funds flow. But there was the concept of blocked funds. And so things like blocked funds fall away. In other words, the entire concept of an immigrant will fall away, and people who cease to be resident for exchange control purposes will now be able to access the same allowances as residents, and you'll be able to take out your 10 million investment allowance and make special application to take out additional amounts. There is a bit of a debate about the 1 million discretionary allowance, and the latest I heard is that the 1 million discretionary allowance isn't available to immigrants. But please bear in mind, much of what I say today has happened in the last 2 months. So it's not absolutely crystal clear how everything works. The second important thing that they've done, and this may simplify or complicate things, is that they've harmonized what a non-resident is with the tax system. In other words, what they've said is that the ceasing to be resident will now reference the tax test rather than having a separate test and a separate process for exchange control. So for those of you who didn't attend last year's discussion, if you wanted to cease to be exchange control resident, you needed to do what we called a form MP336, and it had a whole lot of information that you would provide to the Reserve Bank. And after that process, you would no longer be you would no longer be exchange control resident in South Africa. You would have become an immigrant. With the concept of an immigrant falling away, that process has also fallen away. So now, in order to be an immigrant, you will need to cease to be tax resident. And once your tax residency has been clarified with the SARS, you will cease to be an exchange control resident as an automatic consequence. If I can put it differently, they've harmonized the concept of ceasing to be a resident for exchange control and tax, and the key process now is ceasing to be a resident for tax. Once the tax authorities, the SARS, confirm to SARB that you're no longer tax resident, you will no longer be exchange control resident either. So that's very, very interesting and very material. In my mind, much of what we're talking about today and much of the momentum that we're talking about is moving in the right direction. And what I mean by that is that we are relaxing exchange controls. We're making cross-border transactions easier. But as with anything, there are always teething problems. So with the emphasis on ceasing to be a tax resident now, it begs the question, well, what do I do if I was not a taxpayer? Now, that may sound a little counterintuitive, but there are many people who don't earn taxable income in South Africa, and that's not registered for tax. So how do you do that if you want to immigrate for exchange control purposes and tax purposes, theoretically? Obviously, if you don't earn taxable income and you're not a taxpayer, the tax one is a little moot. Now, it raises all sorts of problems. There are heirs of estates who want to access local estates and have the funds shipped abroad. They may not be tax residents. There are many, many questions. And there's many frustrations as well because there's a lack of clarity. But as with all new things, in time, the systems will be refined and the processes will be implemented and we'll get a better understanding. Currently, there are many, many questions. And for those who are in difficult circumstances, one of the upshots is you kind of do need professional advice if you're going to navigate it. It's quite a complicated area. So being able to deal with the information required and how to deliver the information does require professional advice. But effectively, if you appointed someone a consultant to assist you, and they were working closely with an authorized dealer, which is the financial surveillance department representative at the bank, you would probably navigate the process. I think the upshot, the practical answer is that some people who have never been registered for tax in South Africa may have to register for tax so that they can get tax clearance certificates, which, as many of you know, is a key process in releasing funds that you want to externalize. So let me just sum up where we are up until that point. What I've said so far is that the exchange control regime is being revised pursuant to announcements made in 2020, the February budget. There have been a number of notices released and updates to the manual, which is a policy document administered by the Financial Surveillance Department of the Reserve Bank. The two that we are focusing on today, the one that we focused on so far, relates to immigrants and residency. And the key takeaways from that is that the concept of an immigrant has effectively been done away with, and immigrants now have the same allowances as residents. In addition, the process and the tests for ceasing to be exchange control resident have now been aligned with the tax tests. such that the test for residence is now effectively the tax tests that have always been in place. And just to remind you, there are two ways that you can be tax resident in South Africa. The one is called Ordinarily Resident, and the other is based on a physical presence test. Ordinarily Resident is for those of us that have lived here a long time and clearly regard South Africa as our home. And the physical presence test is for people who don't necessarily regard South Africa as their home, but live here for extended periods on a regular basis, and they can become tax resident in that manner. Just to remind you of one last thing before we move on, the process to immigrate for tax purposes is that when one fills in one's tax return, you need to tick the box saying that you ceased to be resident during the year of assessment that you're filling in the return for, and that will then trigger all of the consequences of ceasing to be tax resident. The most important one, which people should bear in mind, of course, is that you will be deemed to dispose of all of your assets, and you'll pay capital gains on those assets which you would be liable for capital gains tax for, the so-called exit tax. So to some extent, there's less admin in ceasing to be resident, but the tax process has become the key process now in ceasing to be both exchange control and tax resident. The second change which I'm going to talk to today relates to so-called loop structures. Now, before I bring up any diagrams and focus on loop structures, I think that it's always wise, because now we're going to get into a whole lot of detail that may or may not be accessible to all of you. It's always wise to start with what's the takeaway for the day. And I will repeat this on more than one occasion, but the takeaway for the day for me is that both the immigration rules, which I've described, which have changed, and loops, which we're going to talk about now, are significant amendments to the exchange control regime. Okay? And my suggestion to each and every one of you is that whoever assists you with your estate planning should be consulted to see how these changes affect you. What I can tell you is that the changes are material and they will have an impact on most people. The good news is that the momentum or the direction in which the changes are moving is a positive direction. So you will probably be able to achieve some benefits to your estate plan through the changes that I'm going to talk through, particularly the changes now. But if you take away one thing today, and if I could sum it up, it would be the following. The exchange control regime is being revised. It is being revised in a positive direction, i.e. it is being relaxed. And that creates estate planning opportunities for South Africans that they should explore. I will mention it again, but I'm not going to dwell on that again. But that is the key takeaway for today. So the other important change relates to the so-called loop structures, as I mentioned. And I'm just going to share some diagrams, if you wouldn't mind, so that we're all looking at the same thing. So that diagram that I've put on your screen fairly accurately represents a loop structure. And the reason that it's called a loop structure is that the South African party, the little blue guy, we'll call him Flynn for ease of reference. Flynn, you can see, owns very little. Flynn has an estate plan, which is offshore. It's in the rest of the world. We'll talk about jurisdictions a little bit later. In this case, it's a trust, but I'm not limiting people to trust as an estate planning tool. But Flynn has implemented a trust. And just to pause for a minute on estate planning, because it often comes up, why do we have estate planning structures? Remember, from a fiscal perspective, which is where I come from, the reason that we have estate planning structures, or one of the reasons, is that they allow you to beneficially own assets, but not legally own assets. And what I mean by that is, by structuring his estate in this way, what Flynn has achieved is that the trust owns assets, and as a beneficiary of a trust, he can enjoy those assets, but they don't sit on his balance sheet. Now, why is that important? Well, that's important because if a regulator like the Revenue Authority, for example, wants to interrogate Flynn's balance sheet for any reason, those assets don't appear. And a good example of when a regulator does want to interrogate your balance sheet is when you die, because they want to see what you own so that they can calculate your estate duty. In this happy instance, Flynn owns nothing because all of his assets are owned by a trust. So he's achieved the primary goal of fiscal estate planning, if I can call it that, which is shifting his assets onto somebody else's balance sheet, which doesn't trigger any tax for him. So we can see that Flynn's got an offshore trust. The trust has got a holding company. At this stage, I'd ask you to ignore the holding company. It's a tax planner's preference, but it's nothing worth getting bogged down into. And then you can see that the holding company owns Flynn's worldwide assets, including his assets in South Africa, or his former assets, if I could call them that, including his assets in South Africa. Now, what's interesting about that is that this South African leg, where the offshore holding company owns assets in South Africa, and Flynn, via his beneficiariness of the trust, I don't know if beneficiariness is a word, but you know what I mean, via being a beneficiary of the trust, has beneficial access, that would have been prohibited. That would have been called a loop. And the loop, if you can see my cursor, is Flynn owning a South African asset via an offshore structure. Up until December last year, and it's that recent, these were very strongly prohibited, and South Africans weren't able to enter into such structures. So this is a material change in that Flynn can now have, as if he wants to, he can have an estate planning structure offshore, and that can own all of his South African assets and his offshore assets. Let me just pause there. It's not true that all South Africans want to have their primary estate planning structure offshore. Many have got reasons. One of the common reasons given is currency risks. So people perceive that having everything in rand is a risk. But there's no absolute rule to suggest that you have to have your estate planning structure offshore. It's merely a preference of a number of our clients. Now, if I can just contrast that with what is not the universal estate planning structure, but a common one, which was pre the end of December 2020, you can see in this scenario what Flynn had was he had a South African trust with a South African holding company, and that owned all of his investments, albeit private companies, shares, etc. And then he also had an offshore structure, being a trust offshore. And the way that Flynn would have funded both of these is that his holdco's investments would have generated cash. A dividend would be declared to the South African trust. The South African trust would often vest amounts in Flynn, often 11 million a year, which would allow him to take funds overseas using his discretionary allowance and his foreign investments allowance, which, as you may or may not know, is an aggregate of 11 million per annum. Once Flynn had done this for several years and he had sufficient funds abroad, he would have set up a foreign structure. Just to stop there, people often say, at what point do you decide whether or not a foreign structure makes sense? I personally am of the view that estate planning for a certain level of wealth always makes sense. In fact, estate planning for everyone makes sense. Estate planning includes things like making a will. Everyone should have a will. And then looking at whether or not estate planning structures like trusts or insurance wrappers are of assistance. When do you have enough funds offshore to justify a foreign structure? I probably say around the $1.5 million mark. Now, what do I mean by that? Why do you have to have funds overseas to justify the structure? Well, in the modern world, which is very, very compliance heavy, foreign structures are expensive to administer for a range of reasons, which I won't go into today. One generally finds that you have to have professional trustees running the trust and sometimes professional directors running the holding companies. And of course, as with everything in life, these are consultants and they cost money, unfortunately. So these structures can cost anywhere between $4,000 US to $15,000 US per annum to administer. Now, obviously, if you've got 500,000 Rand overseas, okay, although 500,000 Rand is nothing to be scoffed at, these meaty fees, if you're at the $10,000 per annum mark, will quite quickly eat into your capital. So when people talk about having funds overseas to justify a structure, what they're saying is that at least the revenue that you can earn from those funds should be enough to cover the costs of the structure so that the costs of having the structure don't erode your foreign capital. So coming back to the picture on the screen, as I say, this is a very common estate planning structure that we find with clients. They've got two estate planning structures, one onshore and one offshore. And what you find is that the two, because of the historic exchange control rules, have been kept very separate. So the foreign structure couldn't own anything in South Africa, and it was difficult for the South African structure to own assets abroad. So in general, you would have one estate planning structure for South Africa and one overseas. As I say, the proposed change to the looping rules means that you will have to, or will not have to, you will have the ability to consider dropping one of these structures, whether it be the South African structure or the foreign structure. It's probably worth mentioning at this point in time that the looping rules, as you can hear from what I've described, relate to owning South African assets in South Africa. In other words, what hasn't been changed is the foreign investment allowances, which are applicable to South African natural persons. They remain the same. They haven't changed any rules as to whether or not South African trusts can invest abroad. And currently and historically, South African trusts cannot. And the same rules still apply to South African companies investing abroad. In other words, it is, as things stand, currently easier to shift estate planning offshore with an offshore emphasis, should that be your wish. As I say, with the ongoing relaxation of exchange controls, it may become possible for local trusts and local companies to hold assets abroad more easily. And that may then mean that you've got an equal choice between South Africa and the rest of the world, depending on your view on things like the rand, political risk, etc. But as it stands, the removal of the prohibition of loops without any other changes to key regulations means that it is easier to set up an offshore structure currently, which owns both South Africa and rest of the world assets. Okay, so let me just sum up quickly, if I may, before we move on to the next point. And the summary is as follows. As part of the relaxation of exchange controls, the rules prohibiting loop structures have been removed. This means that South Africans can now both directly and indirectly own assets located in South Africa from offshore. Okay, and this will, without doubt, make it easier for South Africans to more freely allocate assets between onshore and offshore when they're doing their estate planning, should they so wish to. So the upshot of that is that all South Africans should look at their estate plan, understand what the changes mean, and then determine whether or not the change is beneficial to them and any changes should be implemented on their estate plan. Process-wise, if we can get into a little bit of drudgery for a minute, process-wise, as things stand, if a South African resident creates a loop, i.e. owns an offshore asset that invests in South Africa, the loop has to be reported to the authorized dealer at the time. Now, what's very important is what I didn't say. What I didn't say was the loop has to be approved by the authorized dealer. I said it has to be reported to the authorized dealer. So you can implement the loop. You don't need permission to do so. And for me, that's very, very important. Once you've reported to the authorized dealer, obviously, if they've got any questions, you can assume that the information will be passed on to the Reserve Bank. And the Reserve Bank, if it's got any questions, will also make contact. But thereafter, on an annual basis, reporting has to be done as to the status of the loop, what transactions have been entered into, etc. But I think that gives you a sign of one of the trends going forward, that the emphasis in future will be on reporting things rather than asking for approval, which in my world is very, very important. So that's the process when you set up a loop. One must contact one's authorized dealer. And just in case that terminology is not familiar to anyone, an authorized dealer is an employee of most of the large commercial banks have one, and they are the liaison between Joe Public, you and me, and the financial surveillance of the Reserve Bank, the Financial Surveillance Department of the Reserve Bank, who administer exchange control. So having access to an authorized dealer is a very important part of any international planning. Okay, so that hopefully gives a summary. We can loop, whoop-de-doo. What does that mean? What should we do about it? What are the benefits? How expensive is it? All of these practical issues arise. Well, there are some very, very interesting consequential tax outcomes that arise from looping. And what I'm going to ask you to do is to not worry about how you get into the loop, but let's assume that Flynn has arranged his affairs such that his South African assets are owned from offshore. And let's look at what the implications of that are from a tax perspective. Okay. And I stress the word tax because people sometimes conflate and confuse tax and exchange control. They're different regimes, they have different mandates, they have different bosses. So it's important to clearly say, I've been talking exchange control now I'm going to talk tax. Okay. The first thing that's interesting is that, let's assume in this particular diagram, you can see that what Flynn transferred into his offshore structure was a South African company. Now, in the historic structure, if I may call it that, when that South African company, if we assume the holdco is the same company, when that South African company declared dividends, in this case it was declaring it to a trust, there was a dividends tax imposed at a rate of 20%. In other words, if the holding company declared a dividend of 100 to the South African trust, the South African trust would have to pay dividends tax of 20 to the SARS. So from a dividend of 100 Rand, it would be left with 80. In this structure, it is possible for the dividend to be taxed at 5%, i.e. that's a 15% saving, or in certain instances at 0%, that's 20% saving. In other words, if the SA company declared a dividend of 100, the foreign holding company would receive 100, untouched by the Revenue Authority's hands. Now, how does that work? That arises due to our double taxation agreement network. And as many of you know, South Africa has a very good, or very extensive, let me use that word, double tax agreement network. Double tax agreements are concluded between countries for two reasons. Number one, they hopefully avoid double taxation on residents of those two countries. And the second thing that they do is they sometimes, as part of the negotiation, get a better deal for their residents. Okay, so it may be that the UK might say to South Africa, while we're negotiating this, we see that your dividends tax is levied at 20%. That's pretty steep. Can we get a discount for our residents? Okay, and South Africa may or may not agree. It just so happens that a number of treaties in the South African double tax agreement network limit dividends tax to 5%. That's a fairly common number, i.e. there's a 15% saving. And there's a smaller list that limits it to 0%, i.e. there's a 20% saving. Now, that might seem quite startling to you. I think, and I'm pretty sure this is right, the reason for the fact that there's such a saving on dividends tax is that when a lot of these treaties were negotiated, South Africa had a system of taxation of dividends called secondary tax on companies. And secondary tax on companies was in fact a corporate tax. So it wasn't affected by the double tax agreements, the dividends clauses in the double tax agreements. Of course, we moved from secondary tax on companies to dividends tax some years ago, I think around 2011, 2012, if I remember correctly. But it hasn't really been available to South Africans because of the exchange control rules regarding looping. Now that looping is gone, if Flynn can structure his affairs accordingly, he can save himself the dividends tax entirely or up to 15% of the dividends tax simply through clever structuring. Now, again, before all of the tax practitioners in the room say the words treaty shopping, there are a number of tax planning assumptions that I've made in that statement. And a lot of these all come back to the concept of substance, i.e. you have to have substance in the jurisdictions that you structure from. So that is taken as a given for the purposes of this discussion, but it doesn't detract from the fact that by simply adjusting his estate plan from what it was previously, and I remind you it looked like that, Flynn will save dividends tax between 15 to 20% of dividends tax simply by altering his structure on current reserves and future profits. The other thing worth noting about this diagram, which is the historical structure, was that Flynn is the one taking the money out. As I said, it's quite difficult for trusts. In fact, it's nearly impossible for trusts to take money out, and it's not optimal for companies to take money out. So invariably, if Flynn decided that he wanted money overseas, as I said to you, the holdco would declare the dividend to the trust, and the trust would vest the amounts in Flynn, who would then take the money overseas. When the trust vested the amounts in Flynn, those amounts went from Flynn's estate, from the trust's balance sheet back into Flynn's estate. And what that created was an estate duty trap for future purposes. In other words, previously, because he had done clever estate planning, the 11 million rand that was vested in him would not have reflected in his estate. At some point, it became more important for Flynn to have money overseas than to save estate duty, so he put it back in his estate. But that carries an estate duty charge. So in the historical structure, which many of us have got, there is an inherent estate duty charge that will be realized later upon Flynn's death that arose because Flynn wanted to take money overseas. If you look at the loop diagram, the funds flow from SA corporate to foreign corporate. They don't touch Flynn's estate at all. So there is no estate duty trap as well. So you're saving all or a lot of your dividends tax, and there's no estate duty trap. In fact, what's very interesting is in this diagram, and I think this is the optimal estate planning piece, is Flynn owns nothing. Okay, his estate plan owns everything. He did have it before, but because of his concerns about the rand, he was putting money back in his name. Two other points worth noting. The ease of moving funds, for those of you who have moved your 11 million or greater amounts using a specific application, it's not very easy to move money overseas. You've got to go through the tax process. You can get audited. It can take some time. There's lots of questions. For anyone who's trying to do the crypto arbitrage, really, really difficult questions that you have to explain. In the present instance, the funds are not going out as a foreign investment. They're going out as a repatriation of profits on an inward investment. And that change in category makes it easier to move the funds. What would have to happen is when the loop is created, Holdco, who would be issued a share certificate by the local company, would have that share certificate stamped or endorsed non-resident. And once that share certificate is endorsed non-resident, then assuming everything's above board and there's no untoward things happening, those funds can be very easily declared and paid abroad as a dividend. So the exchange control process to move, to remit profits abroad to a foreign shareholder is much simpler than using local investment allowances, which is another positive. The final piece that I wanted to touch on, just from a tax perspective, if I may, is that the holding company is quite clearly not tax resident in South Africa unless there were some structural problems which we are going to assume didn't exist. So the holding company, the foreign holding company, is not tax resident in South Africa. Non-residents are only subject to capital gains tax in South Africa in respect of immovable property or an interest in immovable property, which, for example, are shares in a property holding company. So in many instances, you will also save future CGT by entering into the structure. In other words, although there may be a cost to implementing the structure now, it is possible that if Holdco ever disposes of the South African company in future, there will be no CGT on the basis that the holding company is not tax resident in South Africa and is thus not subject to CGT in South Africa. So I'm just going to summarize that chapter, if I may. What I focused on in the last few minutes is the tax implications which arise from entering into a loop, which is no longer prohibited. So what Flynn did was he transferred his South African company into a foreign estate planning structure. And the outcomes of that from a tax perspective were, number one, he dropped his dividend withholding tax to 5 or 0%, meaning he achieved a saving of between 15 and 20% on dividends tax, which is very significant. The structure was also more efficient from an estate duty perspective because Flynn no longer was involved in the process of transferring funds abroad. They were no longer relying on Flynn's foreign investment allowance, which means that nothing had to be paid to Flynn. In other words, there's no estate duty trap created in the current structure as there was in historical structures. In addition, the process to remit funds abroad in this manner is simpler than the process of using a foreign investment allowance. And finally, in many instances, the foreign shareholder will not be subject to CGT in future in South Africa should it dispose of any South African assets unless they are removable property, on the basis that non-residents are not subject to CGT in South Africa unless it's immovable property. So you can see now, none of that was aggressive structuring dreamed up by Andrew Wellstead one sweaty night in summer. Those are actually the natural outcomes of creating the loop, which is now legal. And that's why I say, and why I said at the beginning, and I want to stress it again, everybody needs to carefully sit down with their financial planner, relook at their estate plan, and say, what impact does the looping rules have for me? i.e., does this provide any opportunities to make my estate plan better that I should be thinking of? Now, they are not only tax. I want to stress the tax outcomes that I just summarized and discussed for you are very beneficial, but those are not the only ones. The ability to have funds overseas and own assets from overseas, for many South Africans, is a very comforting outcome. You can hold your assets in real currencies like dollar, etc. And there's a range of things. So many South Africans feel very comforted from the notion that, in fact, they are shifting their estate planning base from South Africa to abroad, rightly or wrongly. So I don't want it to seem like this is all a tax planning endeavor that we're going through now. It's not. There are many, many other benefits that arise from doing so. I see Flynn has popped up. Flynn, have I got 5 more minutes just to round up?
Yeah, I just thought there'd been a number of questions we received beforehand and during the chat. So I know some people would like to obviously get through those if we do have time.
Okay, I'm going to be 3 minutes. The only thing I wanted to say is this, and so it's a repeat, and I don't have to say it for very long. We are part of an ongoing process. In other words, there is a momentum regarding exchange control that shouldn't be ignored, as much of it is beneficial. It's annoying because foreign structuring and planning is complicated both from a tax and regulatory perspective. For example, you shouldn't create a holdco in a foreign jurisdiction unless you understand the rules in that jurisdiction. But if you're willing to put in the effort, and there will be a bit of expense, the benefits may be really, really significant for a number of people. So I think it's a great trend that we're observing. I think it's an exciting time to be alive. That's because I'm a tax nerd and a consultant, so I hope to earn some fees. And I really urge everyone to sit down with your tax planners and to discuss whether or not there are any benefits for you as a client. And that's me, Flynn.
Great, thanks, Andrew. As always, enlightening and definitely making light of a complex subject. Thanks for all the questions. I'll try to get all through them. The first question, Andrew, does the new loop structure work if all your assets are just in cash?
It's a great question. As you can see, the loop structure is focused on owning assets from abroad. So strictly speaking, cash in my personal bank account or liquid assets in my name, very difficult to benefit from the new loop rules. So it's more aimed at assets like companies, properties, things like that.
Great. Nazir also asked, if an SA investor does not want to set up an overseas structure, as you mentioned, because they're very costly, but wants to invest overseas through an SA company, that company owned by a trust, what are the rules?
So that's a great question. And again, I stress those rules haven't changed. So the ownership of local assets has changed, but the investment allowance hasn't. So South African companies have for a long time been able to invest abroad. If I can give you a high-level summary of what you need to do, the type of investments that are allowed by corporates are normally active investments, not passive investment companies. In other words, the type of projects that will get the green light are projects where you're going to go and build a real business that makes widgets or does stuff, farms, whatever. Particularly if you're going to Africa, very exciting. But it needs to be an operating business earning operating income. Passive investment companies, very, very difficult to get approval for to invest overseas.
Thanks. Next question from John. How are offshore joint accounts taxed or viewed at the time of an account holder's death?
It's a very good question. And again, it comes down to what is meant by a joint account. Okay. In my experience, and because we don't have much time and cut to the chase, normally what people intend is when they create a joint account that they both become owners in law of the funds in the account. Now, if I had 100 Rand, Flynn, and I make you a joint owner, at least 50-50, even if we don't specify the proportions that you own in, okay, then theoretically I may well have made a donation to you. I have given you access to the funds. The arrangement, of course, often unwritten, but maybe that during my lifetime, although you're a joint owner, the funds will remain mine, but on my death, you will inherit the funds, okay? And the joint ownership there is to make your access to the funds seamless. In that case, the funds would remain mine. I'd pay a state duty on my death, and then you would take them over. But in my view, it's always good to document what the intended arrangement is so that you don't have SARS ascribing characteristics to it that you don't want to.
Okay, great. The next question you did mention in the beginning, the MP336. The question is around if one has already immigrated, so the MP336 has been submitted and has not been in SA taxpayer since 1994, how would SA-based RAs be treated when they mature, bearing in mind that the premiums were funded from a foreign source? No tax deductions were given on these premiums.
Okay, so this is not my area of speciality, and maybe you guys can help me a bit, but I will tell you some of the rules I know. Particularly around pension funds and RAs, there was a lot of noise because previously, when you completed your 336 and then emigrated for exchange control purposes, you could access those funds and take them abroad. Now, one of the much vaunted rules is that, certainly as regards pension funds, and again, it's not my field, that you need to have ceased being tax resident in South Africa for at least 3 years before you can access those funds. So people who did their MP336 effectively before the end of Feb, I believe, or March, I think before 1 March of this year, they're under the old process and under the old rules. If you submitted for financial immigration after that date, then you will be subject to the new rules regarding the 3 years tax residency issue.
Okay, great. A lot of tax questions, so I'm going to slip in an exchange control question, as you mentioned, different. You mentioned the authorized dealers, and this is obviously a new process for them. A lot has changed in their world. In terms of just, I guess you can't speak for the whole market, but what's your sense in terms of where they're at in understanding the process, getting their forms, everything in place, and helping with this structure?
It's a great question because, as I said, there wasn't a lot of focus on the ex-con changes during the pandemic, and I think some people thought they wouldn't happen. And for a lot of people, it's like removing blinkers and you're in a bright sunlight. It really takes a lot of time for your eyes to adjust. The other thing is, the way ex-con works is their rules are not that detailed. So they don't give you chapter and verse, they state it in a policy way. So there's a lot of really interesting discussions going on. There are many, many questions people would ask that I don't know the answer to, and probably nobody knows the answer to. And we're finding our way. We're talking to the authorized dealers. We're talking to the Reserve Bank. We're talking to clients, and it's an ongoing process. What I can say, and this is my view, but I do believe this is a legal question. The way that they amended the rulings was that they deleted the sections which prohibited loops. Okay. So in the rulings, there was a section that said, thou shalt not loop. They deleted that, which means all loops are legal. So when you encounter an argument that says, that's not really what was intended, that kind of loop is not okay, I'm very quick to say, okay, just show me where it says that. And don't show me the explanatory memorandum. Let's go to the rulings themselves. So I think that there is some strong legal arguments for clients that want to do things, that there are no loops that are prohibited. And as I say, it's a legal question because the legislation has been amended. It's now an interpretation question, it's not a policy question. So, yeah, I hope that answers that.
Yeah, it does. Thanks, Andrew. And just sticking with investments, is investing in unit trusts or any other type of investment from obviously offshore, they're all treated the same, or,
yeah,
you know, obviously unit trusts have their specific rules. You don't see any impact there?
Again, you know, the loop prohibition, unless there's with a particular investment, unless there's some sort of specific prohibition, and obviously I don't know all of those rules specifically, I can't think of any, but as a general rule, you're allowed to use your offshore funds to invest back in. So if I choose to do it in listed equities or unit trusts or whatever the case may be, the fact of the matter is nobody can put up their hand and say, no, it's a loop, that's a problem. Quite interestingly as well, for those who are taking a more conservative reading, and of course there's always going to be a spectrum, some people are saying, yeah, but actually if you go back to the core rule, which is the regulation, there's a regulation 10, which is often bandied about. They're saying, well, you can't do this. That's the one that deals with exporting capital. The answer to that, I believe, is, hold on a minute. If they needed specific loop rules, okay, and that's what prohibited what I want to do, then you can't rely on regulation 10, because if that prohibited what I was going to do, you didn't need the loop rules. So you get yourself into a logical conundrum. So again, I think the changes, I think the impetus is to relax exchange controls, and they should be interpreted in that way.
Great, thanks. Next question from Maurice. How does one move the assets in the local trust to an overseas trust? So there's local trust owns 50% of the shares in a private SA company, owns no other assets, tax resident in Mauritius, but have not submitted yet the latest tax return, and a non-SA tax resident.
Okay, so it's quite detailed, but it raises some very interesting issues that I'd like to address. How do you move the assets, and should you? Okay. Now, the first issue there is, are you going to pay CGT? I would argue, if you get somebody who can run Excel properly, if you do the numbers, the future savings on the estate duty, the dividends tax, and the future CGT would justify paying CGT now in any event, even if you had to sell it outright. In addition, in the pandemic era, a lot of valuations are much lower than they've been historically. So you can probably get a favorable outcome from a CGT perspective just on a valuation. If you still don't like that answer, because I've encountered a few clients who don't want to prepay CGT, if I'm honest, the two things to consider, and the two things you should be talking to your advisors about are, number one, CGT. Is there a way that I can reduce my CGT to the most efficient outcome, which is still legal? Okay. So you know, Flynn in that diagram wanted to sell his assets, but of course he wanted to manage his CGT. That's the one thing you should talk about. And there are techniques that can be applied. The second area that I think is really important is, if your assets are worth R1 billion, how do you get R1 billion out of the country and ship it around in a big circle? And do you have to do that? And again, you should be looking for outcomes, I believe, that don't require too much shifting of hard currency around the world and back in. So those are the 2 points you should be talking to your advisors about. Can I legitimately reduce my tax to get the best outcome on a tax perspective? And what are the ways that I can do the transaction that doesn't need R1 billion moving around? Now, in some instances, you have to, but there are instances in which you don't.
Great, thanks. Yeah, I'm not, this question I'll ask, I don't quite understand the question, but immigrants who are now enabled to release blocked RAND and blocked assets, are they required to have their proprietary interest valued, even if there is no intention as to the change of ownership or disposal of such assets?
So if your assets were blocked, you'll now be able to own them from overseas, which is great. Valuation is a key point. You can imagine the one thing that both the SARS and the SARB are going to be looking at very carefully is valuations. So if your asset has been blocked and it's released, well, now you can own it. Great, no problem at all. If you want to externalize it, you're going to have to get a valuation. Or let me put that differently. The onus rests on you to prove the valuation. So normally an independent valuation is required.
In those diagrams you had a company underneath each of the trust. What happens if you are merely a salary employee and you don't have a company? Does that change anything?
It doesn't change anything. And again, it's a little bit too detailed to go now. For those people who own their assets directly, i.e. they have an estate plan, this is a great opportunity to estate plan in arrears, i.e. there are some structures that you can use now today that will forgive you for the fact that you did an estate plan in the past. You'll be able to put in a really great estate plan offshore, which protects your assets, and you'll not be prejudiced by the fact that you did an estate plan in the past.
Great. I know we're running out of time, so I'm going to ask one last question. It's a bit broad, but you have, during your talk today, made some very key points, particularly in your summaries. So I guess we've spoken a lot about estate planning today. If you had to list maybe 2 or 3 considerations when doing your estate planning, based on the changes that have happened and are pending, what are the insights from your perspective that you would bring into your estate planning when you speak to your wealth advisor or expert?
So I think most people, and it's not only tax benefits, I think most people will feel more comfortable owning their assets abroad. That's my experience of interacting with taxpayers in South Africa, number one. So there is benefits to owning assets abroad and being able to choose where you want to deploy your income. Even if you want to bring it to South Africa, you can bring it back. So there are very few circumstances where the discussion, even if, remember the guy you mentioned who's got cash in his name, at least he's re-looking at it and he's looking at what he can do. Flynn, you've probably had the experience. We've got clients who have applied for specific approval to remove more than 11 million, and they've had great outcomes. So people are able to shift your money. So if you're in the school of thought that thinks that it is preferable to have a good portion of your assets allocated overseas, this is a great time to be doing it. And that should be the emphasis of the discussion. I want 40% of my assets outside of South Africa and 60% in. What's the best way to do it? Those are the issues I would be looking at. Great.
Thanks, Andrew. That brings us to 11 o'clock. Once again, thank you very much to everyone that's joined us today. Any questions, and those that we didn't get to, please feel free to discuss with your wealth advisor or portfolio manager. And I know that Andrew has made himself available should there be any other questions we haven't answered today. And thank you, Andrew. Thanks again to everyone that logged in, and we look forward to hosting you at our next webinar. And I trust that you have a great day further, and everyone stay safe. Thank you very much.